to Delegate Tolles, House Bill 1433. And Delegate Tolles, while you make your way over, I'm going to start calling out names, and if you could start coming up, unless you have a particular panel. Okay, well, you come on over. So we'll have Kara Anderson, we have Emily Virgin. Are we having Judge Caroon come up now, or is he still here? Oh, there it is. Okay.
Who, Ryan? Somebody's virtual.
Liz
Yes.
Liz Ryan is virtual.
Well, I've got
Monique Dixon, virtual.
Okay, all right. So let's go to, and we also have Ikra Ashraf, I'm sorry. And I think that will do it. We'll continue calling our favorable witnesses after this panel.
Emily.
So Delegate Tolles, whenever you're ready, you'll have 3 minutes.
Wonderful. Thank you so much, Madam Vice Chair and colleagues on the judiciary. This bill is in support, I'm testifying in support of 1433, juvenile jurisdiction. House Bill 1433 attempts to address automatic charging of youths as adults. It is not a full all-out end of automatically charging youths as adults. Instead, it is a narrowly tailored approach, a pared-down approach that will begin to move the needle in the right direction for certain charges. HB 1433 will alter the jurisdiction of the juvenile court by repealing provisions specifying that the juvenile court does not have jurisdiction over a child alleged to have committed certain acts. It is important to note that for this bill, that charges for this bill of first and second degree murder, rape, and carjacking will remain under adult court jurisdiction. We are paying more money, taking longer time to end cases, and we are getting worse public safety outcomes. I encourage you to take a more thorough look at the DGS submitted testimony to see how this bill will create public safety create a better public safety outcomes for Maryland communities, and Kara will go into more detail about their testimony. The process needs to be streamlined because we are spending, again, more money, and cases end up being waved back to the Department of Juvenile Services anyway. When youth are charged as adults, they end up waiting over 100 days longer than youth charged in the juvenile system. Enacting this approach would save DGS at least $17 million, where the money could be spent on other services. This is a critical issue for Maryland. Only Alabama charge children as adults at a higher rate than Maryland. In most cases, it's Black kids that are impacted more than any other race of children. And I'm trying to go through this quickly. The data is compelling. If you refer to the racial equity impact note that was given, by DLS, you will see that the fiscal year 2023 in the Governor's Office of Crime Prevention and Policy, or whatever we call it, like as we like to say in judiciary, reported a total of 737 youth were charged as adults for crimes of violence by the state. And it shows that 81% of these individuals were youths of color, with the majority being Black individuals. In fiscal year 2024, DGS reported a total of 604 youth were adjudicated for crimes of violence. Of those 604 youth, 89% are youth of color. The circuit court and juvenile courts processes share similar racial distribution for youth charged with crimes of violence. The statistics show, if I could finish briefly, thank you, Madam Chair. Statistics show and provide evidence of substantial disproportionately in the proportion of youth in color charged with crimes of violence. The disparity ratio for youth of color under the age of 18 means that the youth these youth are 5.5 more likely to be charged for crimes of violence over their white peers in juvenile court. For youth charged as an adult for crimes of violence heard in the circuit court, youths of color are charged as adults slightly over are slightly overrepresented in cases adjudicated by the circuit court and are more likely to be charged as adults for violence of crimes, for crimes of violence compared to their white youth. Overall, in closing, Black youth are overrepresented and are more impacted by crimes of violence charges, whether they're adjudicated in juvenile court or circuit court. Therefore, they're experiencing harsher penalties. And this is precisely why this is a legislative Black Caucus of Maryland priority. If you look at the numbers and any other government agency perform this poorly, we will be looking to rectify the error. Why not in this case? This is not an overnight fix, but in the case of children, they are one of our most important assets. This bill is supported by retired judges, the community, and you will hear from many advocates. Colleagues, I urge you to vote favorable for HB 1433. Thank you, Madam Chair, for your indulgence.
You're welcome. We went over a little bit, colleagues, but we're going to have a whole lot of testimony, and I wanted to make sure that the sponsor was able to get out her positions, because there are going to be a lot of witnesses for this bill. So we're going to move on to.
Oh, I'm sorry. Can we go to?
Yep, Kara, you want to go next?
Madam Chair.
All right, good afternoon, Madam Chair and members of the committee. My name is Kara Annenson. I am the Director of Legislation, Policy, and Reform at the Department of Juvenile Services. DJS supports HB 1433 because it promotes efficiency, fairness, and better public safety outcomes for Maryland's communities. The current system negatively impacts detention center operations, delays access to rehabilitative services, and disproportionately impacts kids of color. In addition, the current system is incredibly costly. DJS spends roughly $17 million annually to accommodate youth charged as adults in juvenile detention facilities, and is unnecessary since judges are choosing not to use the adult correction system in nearly 85% of youth automatically charged as adults cases. This legislation does not change the current law that requires youth who are alleged to have committed the most serious offenses, such as rape, murder, and carjacking, to be automatically charged as adults. In addition, the current law allows for the waiver process, the ability for prosecutors to ask the juvenile court to move a case from the juvenile court to the adult court for prosecution and sentencing. HB 1433 takes a measured approach to improving public safety outcomes for youth by codifying the current process, recognizing the long-standing research on adolescent development, and prioritizes service and treatment for youth while maintaining public safety. For these reasons, we urge a favorable report.
Thank you, Madam Vice Chair, members of the committee. My name is Emily Virgin, and I'm the Director of Advocacy and Government Relations at Human Rights for Kids. In November, we released our latest report entitled Disposable Children, which details the staggering rates of childhood trauma, abuse, and neglect among the population of children who are convicted as adults in Maryland. What our research showed was that children who come into conflict with the law are almost universally contending with early childhood trauma and unmitigated adverse childhood experiences. Nearly 70% of the children who were tried and convicted as adults had experienced at least 6 out of 10 ACEs prior to their incarceration. About 74% had experienced physical abuse, and around 40% had experienced sexual abuse. The average age that this group of children first experienced abuse was 6 years old. The current system of allowing these children to be automatically charged and treated as adults means that children with severe trauma sit in detention with no services, treatment, or accountability until after their transfer hearing takes place. Most of them are housed in a DJS facility but are unable to receive those services. It takes about 4 months before children are transferred to juvenile court, and it's important to note that most of them are transferred to juvenile court. As Ms. Annenson said, over 80% of them. This legislation would simply start cases in the system where they already end up and allow children to begin receiving treatment much sooner. When a child comes before the juvenile system, their cases are processed fairly quickly. They're held in detention for an average of 71 days. During this time, DJS conducts their risk assessment, develops a treatment plan tailored to address the child's behavior and their background and reduce the likelihood of recidivism. When children commit crimes, swift consequences and treatment for underlying trauma are paramount for the protection of public safety of all Marylanders. We urge a favorable report.
Whoever's ready.
Good afternoon, Madam Chair and members of the committee. My name is Ikra Ashraf, and I'm a student attorney in the Youth Education and Justice Clinic at the University of Maryland Francis King Carey School of Law. I am here to testify on behalf of the clinic, as well as from a personal perspective, as I have a close family friend currently charged as an adult in Maryland awaiting judicial review. Out of respect for their privacy and given the pending nature of their case, I won't provide further details. However, I want the committee to understand that if HB 1433 were in effect, my loved one would not be confined in an adult cell right now. Since 2021, more than 2/3 of children charged as adults have been returned to the juvenile system. Not only does this statistic reveal that the current system is ineffective, there is a human cost. For a child spending that time in an adult facility, the situation is dangerous even in moderation. For example, adult facilities are not equipped to house children. Since children are legally required to be separated from adults in custody, children in detention centers are often held in solitary confinement. Additionally, the children staying in these detention centers are prone to victimization. Human Rights for Kids surveyed individuals who had been charged as adults in Maryland and held in adult facilities. Approximately 82% reported they were harmed by staff or other incarcerated individuals at least once during their stay. My own family friend has shared that they had been verbally harassed. What might appear to be a short stay on paper often inflicts long-term emotional damage in the child that endures it. Given the inefficiencies of this process and the lasting trauma it inflicts, it is important that Maryland narrow and limit the offenses for which a child can be charged as an adult. We should expose as few children as possible to the adult criminal system. For these reasons, the clinic strongly supports House Bill 1433 and requests a favorable report. Thank you.
Thank you, Judge Crowe.
Thank you. Madam Chair, Acting Chair, Delegates, Phil Karoum, speaking based on my 24 years of serving as both a juvenile and an adult criminal court judge. I should add, I'm not speaking on behalf of the court system, but speaking on behalf of nonprofit group Maryland Alliance for Justice Reform. I'd like to point out that the current system charging children as adults is a major conduit of the school to prison pipeline, in the sense that when we charge those kids and make them spend an extra 100 days in pretrial detention or otherwise, that makes about 3/4 of them drop out of school, and they never return. When they are put out of school, they are then hanging around with the worst possible companions in the adult system. Unfortunately, there is access to illegal drugs in those systems. While you heard lots of bad things about the Department of Juvenile Services today in terms of how inefficient and short of resources they are, the adult system is 2 or 3 times worse. There are no school programs for them there. If a child is charged as a juvenile, however, they stay in school. They have regular counseling, even in pretrial detention. They are kept away from illegal drugs, and they're in a much better position to succeed when, as you have heard, more than 80% of the charges are dismissed. So it is a system which costs the taxpayers lots of money. It creates more of unemployed school dropouts who will get in trouble worse. And for all those reasons, I strongly urge you to support House Bill 1433.
Thank you. Are there any questions for this panel? Yes. Delegate Kaufman.
And I have 2, if that's okay. Delegate Tolles, thank you for bringing the bill, very important bill. It won't surprise you that Mr. Schellenberger is opposed to your bill. And so my question is, as he often does, in his testimony, he lists a series of terrible anecdotes. So what I wanted to know is, do you think that there's a point there that the most, people with the most egregious offenses should be tried as an adult, or do you think it's cherry picking? And my other question is for your experts on the panel. The judge talked a little bit about this, and the law student talked about her friend who's been verbally abused. But do we have any long-term studies on the benefits of juvenile justice or juvenile services rather than adult incarceration? Do kids fare better 10, 20, 30 years later? So whichever order you want to take those questions in.
Sure, I'll start. Thank you, Delegate Kaufman, for your always great questions. I would say I did not read Mr. Schellenberger's testimony because I'm sure I can guess what he is saying. So it's no shocker there, but I will say that, as I indicated in my opening remarks, that it's only, the most egregious crimes of murder, first degree, second degree, manslaughter, rape, even armed carjacking would still remain under adult court jurisdiction. And they would have to go through the process of getting waived down through the courts. And so that's a current process that already exists that does not change. Where we see a lot of the issues is where we have, children with, handguns or first degree assault or some type of firearm. Those are charges that we are looking to start in the juvenile court jurisdiction because they get waived back anyway to juvenile court, most likely. And so instead of starting off as an adult in adult court, waiving them back would be the most ideal approach. And would, as we talked about savings, harshness, all of that is extremely important for why we need to push this bill forward because they're coming back anyway. I will let Kara, add on to that. She's itching to add on to it, so I know she can add on to that. And in terms of your second question, I will refer to the human rights to talk about any studies regarding juveniles.
I was going to touch on that.
Yes.
Oh, you can touch on that as well. Hey, yes.
Yes, and I did want to let you know, I was paying attention to when you said the carve-outs the first time, but given the opposition testimony, I thought it was good for you to reiterate it.
Oh, thank you.
But go ahead, I'm sorry.
No, thank you. I know. That was for those that were listening in case they don't listen as good as you do, Delegate Kaufman.
Okay, well, thanks. If you could answer the second question.
Yes.
I was just going to say, there's lots of national research showing longstanding that starting kids in the juvenile court system have better public safety outcomes because young people are able to access treatment, education, and services. And I think former OJJDP Administrator Ryan can speak really about that just in Maryland and across the country.
And, okay.
If it's possible to provide a response in advance to the horror stories that another witness might tell of juveniles in pretrial detention, those incidents that you may be about to hear of are just a tiny percent of all of the hundreds of children that go through the Hickey School and other juvenile detention facilities. And I think the concept of sending more and more into adult pretrial detention isn't justified by that in the sense that the adult system is much more dangerous. There are more assaults that occur there, more deaths that occur there in the juvenile system, and it is a rare and highly unusual thing, which obviously should be addressed by Department of Juvenile Services if there's a problem in detention with assaults. But that doesn't mean that one should punish the other 99% of kids who could better be handled in the juvenile system that way.
Very quick follow-up, Madam Vice Chair. Thank you. And I already articulated someone's opposition, but Delegate Tolles, do any of the other 23 state's attorneys support your legislation?
I would say probably not. And that's okay, because, as prosecutors, they want the ability to be able to decide, where the jurisdiction would be. But as I indicated, this does not allow them to not ever do that, you know? So it would start off with DJS, with some of the charges I indicated, like armed robbery, handgun, but where I think it's important for the prosecutors to focus on is some of these most egregious cases that may start in DJS, but then, that may start in adult, court, and then they can still decide if they want to be able to, feel like, hey, it's a first offense, they are not, maybe it was self-defense or whatever reasoning they may feel like that particular individual could be waived back down to, juvenile court. But I think, as I indicated, and Kara can add on to this, but I think what the most important issue is that we have more minorities that are impacted by this. And we know that Maryland incarcerate Black individuals at a higher rate than any other group. And so we want to be able to really take a look at that and see how we do things differently. And this bill will give us the ability to do that by starting some of these kids off in the juvenile court, allow for them, as you heard previously, to get some resources, get some support that they need in order to be more productive citizens in society. But when you start them off at adult court, it is a much harsher, jurisdiction, so.
Thank you, Madam Chair. Thank you, Delegate Tolles.
Do you want to add? I'm sorry.
No.
Emily,
Well, I just one quick point, Delegate Coughlin, on the issue of there being serious offenses that the prosecutors are concerned about. If this bill were to pass and those offenses, those children started in the juvenile court, the prosecutor always would have the ability to seek to transfer the child or to waive the juvenile court jurisdiction and try the child in adult court, and a juvenile judge would make that decision. So they're not stuck in juvenile court. They could still be in adult court.
Thank you. Delegate Taylor?
Madam Chair. And Delegate Tolles, thank you for bringing this bill. This is also considered the YES Act, right?
yes, correct.
I also wanted you to know that more of our sorority sisters have arrived, and they're all sending you pink and green love, including my cousin Sandy Banks back there. But I do have a question. Anybody that can answer this question. If a child is sent to an adult facility, what does that look like for them? Are they placed in a cell with an adult? Are they isolated? What does that look like? And then for the judge, you mentioned that there was some percentage that were dismissed ultimately. What was that percentage again? Can you repeat that? And
So the percentage that comes from the Department of Juvenile Services keeping statistics is, I think it's between 81 to 87%. Maybe it's an average of 85%. Have their charges dismissed and are sent back to juvenile court after waiting on average 100 days for their turn to come up for that hearing. If the case is started in juvenile court has written into its rules that we handle those cases much more quickly. So they would have their hearing and the decision would be made to keep them in juvenile or send them to adult within 60 or 70 days at tops. So, but during that 60 or 70 days, they could stay in school. They would be in the company of other juveniles. Your other question was, what does it look like when they are in adult prison? And the answer is that there is a statute which says they should be kept in a way that is out of sight and sound of adult offenders. So there should, in effect, be a separate area for juveniles. However, until they turn 18, in which case they are then thrown into the adult population and really don't mix well. They really become victimized at a much higher rate by the older, more experienced prisoners. But because they are stuck in this smaller area, there's fewer facilities for them there. Some people say that it is comparable to solitary confinement because they do not have the same opportunities to socialize and have other programs as older prisoners might. But again, the services and the education and the job training in the adult system is way more scarce than it is in the juvenile system. In the juvenile system, every single child, every single individual has education, treatment, and ultimately, if they don't stay in school, job training. In the adult system, 1 out of 10 prisoners has the chance to participate in correctional enterprises for job training. And it's a very small percentage of adult prisoners who ever complete their GEDs or go on with their education.
Thank you.
Seeing no further questions, that concludes this particular panel. We'll move on to the next panel. So we're going to go ahead and have Monique Dixon, and I believe that's Liz Ryan next.
Okay.
So Ms. Ryan, if you want to start, and then we'll go to Ms. Dixon. There you go.
Good afternoon, Madam Chair and members of the committee. I'm Liz Ryan, the former administrator of the Office of Juvenile Justice and Delinquency Prevention at the U.S. Department of Justice. Thank you for the opportunity to speak in favor of HB 1433. I'd like to focus my comments briefly on why starting youth in the juvenile justice system rather than the adult criminal justice system enhances public safety. The research is clear. Youth who enter the adult criminal justice system are much more likely to reoffend and to do so more violently than those who are in the juvenile justice system. When I served as OJDP administrator, we conducted an analysis of the research on this, much of which OJDP invested in. For example, 6 large-scale studies conducted across 5 jurisdictions examined the deterrent effects of transfer laws. All 6 studies found higher recidivism rates among youth who had contact with the adult criminal justice system. The juvenile justice system is designed specifically for young people, incorporating research on adolescent brain development and behavior. The Office of Juvenile Justice and Delinquency Prevention and national experts emphasize that the juvenile justice system provides developmentally appropriate interventions that reduce reoffending, evidence-based services, which significantly lower recidivism, mental health, and educational support, which the adult criminal justice system lacks. That's why I, along with 4 other OJDP administrators, have publicly stated our support for this legislation. In closing, the adult system has been proven ineffective at rehabilitating youth or keeping communities safe. It increases recidivism and exposes young people to conditions that make them much more likely to commit future crimes. Maryland has an opportunity to come into alignment with science, data, and proven solutions. I urge support of HB 1433. Thank you.
Thank you. Ms. Dixon.
Good afternoon. I am Monique Dixon, Executive Director of the Gibson Bank Center for Race and the Law at the University of Maryland, Carey Law School. We appreciate the opportunity to provide both written and oral testimony on House Bill 1433, which is a step in the right direction toward ending Maryland's inefficient, racially disproportionate, and harmful practice of automatically charging children as adults. Limiting the automatic charging of children as adults could positively impact Black children who are overrepresented among these young people when compared to their statewide representation. National research shows that Black children are overrepresented in both the youth and adult criminal legal systems, in part because they are often seen as being older and less innocent than their white peers. Consequently, Black children are often unfairly feared and criminalized by the general public and decision makers. House Bill 1433 could significantly impact Black children by beginning more cases in the juvenile court system where they would have access to treatment and services that are unavailable to them in the adult system. Also, because over 80% of children who are charged as adults have their cases either transferred to juvenile court or dismissed House Bill 1433 would result in a more efficient process by allowing more cases to begin in the juvenile court system. And this could result in a cost savings that could be used for more treatment and other services. In our view, all cases involving children should begin in a system that understands children are different from adults and that they are more responsive to treatment, rehabilitation, and accountability systems. We respectfully ask that you issue a favorable report for House Bill 1433. Thank you.
I believe that's Delegate Hornberger, right? Okay, Delegate Hornberger. Just wanted to make sure I had the right light associated with the right individual.
Thank you, Madam Vice Chair. And I'm from Ways and Means, so this will be more of a question from that perspective, serving on the Educational Subcommittee. So this population that is sort of at the edge of the juvenile spectrum, are they being detained while they're awaiting trial? Is that accurate to say? So the proposal of the bill is to detain them with the younger cohort, right? The juvenile population. Is that accurate?
Yes.
Do they have the same segregation requirements that you just alluded to, this gentleman on the end? Judge, that they would in the adult
That's,
incarceration areas?
I can just touch a little bit on that, because right now, actually, the overwhelming majority of DJS's detention centers are young people charged as adults, because in 2015, the law was changed to say that young people who are automatically charged as adults at the point of bail review could be held in a juvenile detention facility and not in an adult jail. So we're already serving those young people. We're providing them education and services. So they're being held with us pre-trial, but they're still being automatically charged as an adult.
So for this age cohort, which is 15, 16?
No, it is 14, 15, 16, 17.
Okay, so 14 to 17, depending on the severity of the crime, you will either go to a juvenile facility or an adult facility. Is that accurate?
You'll start in the adult, and you'll be, if you're automatically charged as an adult, you'll start in the adult system. The court can then move you to a juvenile detention facility pending your transfer hearing.
Okay, so my concern becomes if this population was identified to go to the adult court, this bill seeks to change that, automatically send them to the juvenile court. What is the disproportionate impact they may have on the folks that are in the juvenile facility?
They're already in our facilities right now.
But not at this offender level?
At this offender level, yes.
If the judge determines that they should go there?
Yes, they may, yes.
Okay, so is there concern that?
No, the department is currently housing these kids every single day. We're able to serve them.
Well, if they're already doing that, then why do we need the bill?
Because what the bill does is saying where they're starting their case. So when a youth is automatically charged as an adult, they're going through the adult justice system. They're being held in a juvenile detention facility, some of them, pending that decision. What this bill would do was say that they would start their entire case in the juvenile delinquency process, and then if a state's attorney felt like this case should go to the adult system, they could then waive that case to the adult system.
And upon that decision, would they be automatically transferred to the adult facility?
If they were waived to the adult system, yes.
Okay. All right. Thank you.
Okay, seeing no further questions, that concludes this particular panel. We'll keep moving.